Thank you, Madam President. I beg to move that a bill entitled An Act to Provide for the Regulation and Control of Gaming and Betting and Matters Related thereto be now read a second time. Madam President, an overhaul of the gambling framework in Trinidad and Tobago has been outstanding for a very long time. And may I ask how many minutes I have?
You have 45 minutes.
Thank you very much. The gambling sector is governed by archaic legislation, which predates the advent of the cellular phone in 1973 and the internet in 1983, and other modern mediums through which gambling now takes place all over the world. I want to repeat that. Our current gambling laws predate the advent of the internet, which is one of the main areas of gambling now at this time. This sector continues to be unregulated in Trinidad and Tobago, despite the fact that the legislation is archaic. The outdated gambling framework is also not in sync with our international obligations. With respect to the Financial Action Task Force revised 40 recommendations, which in themselves have had over 10 updates since the original revisions in 2012. To give an overview of how dire the situation is from an AML CFT compliance perspective, I will quote from paragraph 90 of the Trinidad and Tobago's third round mutual evaluation report of May 2007 as follows. Private members clubs. There are 20 private members clubs registered with the Board of Inland Revenue, which operate casinos. Let me repeat that. In 2007, the FATF had determined there were 20 private members clubs in Trinidad and Tobago which were operating as casinos. In addition, there are 147 recreation clubs which entertain gambling activities on a smaller scale. There is no association of private members clubs or recreation clubs in Trinidad and Tobago. This is in 2007. Private members clubs are monitored by the Miscellaneous Taxes Department of the Board of Inland Revenue through field visits and audits. No AML CFT guidelines or AML CFT reporting system is in place for private members club. I'll now move on to paragraphs 12 and 318 from Trinidad and Tobago's fourth round mutual evaluation report, June 2016, private members clubs. There's a significant presence of private members clubs within the country, which provide gambling activities through gaming tables and machines that are similar to casinos. The high cash turnover of these institutions, the nature of the clientele, and the non-rigorous application of AML CTF requirements are a cause for concern. It is of note that some banks have refused to do business with some of these entities as a result of perceived high risks of the industry. That situation of banks not willing to do business with these private members clubs, which are really casinos, continues. 318, there are inadequate measures in place to prevent criminals and their associates from holding or being beneficial owners or having a significant or controlling interest or management function in these entities. This is of particular concern in private members clubs that provide gambling activities through gaming tables and machines that are similar to casinos in Trinidad and Tobago. Given the significant risk for money laundering and terrorist financing by such entities, this deficiency ought to be addressed. Madam President, to seal the proverbial nail in the coffin, in Trinidad and Tobago's third enhanced follow-up report on technical compliance re-rating June of 2019, recommendation 28, which refers to the gambling sector, was one of 4 recommendations still listed as partially compliant. The current framework is certainly not geared towards realizing as a country the true potential of the gaming sector as a significant source of government revenue. That is another significant concern. the estimated revenue that we should be getting from the gambling sector is considerably more than what we get. What we actually get is a fraction of what it is estimated and determined that we should be getting by way of taxation from the gambling and gaming sector. In 2017, I'm advised, the gambling industry's tax compliance rate in Trinidad and Tobago was just 27%. 253 clubs registered, only 69 were compliant with respect to the Inland Revenue Division. 2018, this dropped to 18%. 251 clubs, only 47 were compliant with Inland Revenue. In 2019, the tax compliance rate was just 15%. 246 clubs registered, only 36 compliant. For the first quarter of 2020, prior to the close of the industry in March 21, 2020, because of public health restrictions, of the 247 clubs registered, only 18, and this is before COVID, had paid taxes to the Inland Revenue Division in accordance with assessment. This is a 7% compliance rate. It is therefore imperative for these and other reasons, modernization through proper regulation, anti-money laundering, counter-financing of terrorism compliance, and revenue enhancement, that we decided, this government, since 2016, in the first session of the 11th Parliament, when a previous version of this bill was brought before this Honourable House, that the time has come once and for all to do the patently obvious and bring about much-needed change and stability to the gambling sector. The bill before the Senate, this bill, which has been amended to remove the special majority requirements because the opposition has been resolute in blocking the passage of proper gambling legislation, contains 88 clauses divided into 11 parts. It's a simple majority bill. And the Attorney General is here and will explain exactly what legislative work has been done on this bill. Despite the fact that it's a simple majority bill, the bill is robust and brings the country in line with international AML CFT obligations. It's to be noted that the Anti-Terrorism Act is also a simple majority bill, is also robust and meets international obligations. In other words, much can be done with little. I now propose to address the salient portions of the bill. But before I do that, I want to read into the record a message I received from persons within the sector. Apparently, a former disgruntled president of the, what's the name of this association? Just one second, Madam President, the Barkeepers and Operators Association of Trinidad and Tobago. They had a change of leadership last year, and apparently a former disgruntled president of that association has been meeting with the opposition, so I'm told, in an effort to get the opposition to protest against this legislation. I want to put on record that the bill before us has nothing to do with amusement gaming machines. Amusement gaming machines, which are the machines that are in bars and are limited in terms of their payout a small amount, are regulated by another piece of legislation, the Liquor License Act. And I'm saying this to preempt any false allegations coming from the opposition that this bill is going to destroy the bar industry. This bill has nothing to do with the bar industry. The bar industry and the amusement gaming machines, which are used in those bars, are regulated by the Liquor License Act and not by this legislation. So coming to the bill now, Clause 2 of the bill includes a number of definitions set out to marry the provisions of the bill with existing AML CFT framework in Trinidad and Tobago. These definitions include a definition of AML, CFT, PF, beneficial owner, and supervisory authority. The objectives of the bill are set out in Clause 4, touch upon three main areas that I referred to earlier. Clause 4A of the bill specifically is designed to protect minors and other vulnerable persons from being harmed or exploited by gambling as one of the aims of the bill. This cannot be understated, Madam President, because the deleterious and dangerous effects of gambling on the young and vulnerable in society are severe. Part 2 of the bill deals with the Gambling, Gaming and Betting Control Commission, sets out matters concerning the status, function and administrative arrangements of the Commission. Clause 5, Part 2 of the bill, establishes the Gambling and Gaming and Betting Control Commission, which will be a body corporate. To ensure accountability from the top, Clause 5 of the bill establishes the members of the board and determines that the members should have the members of the board of the commission should have a background in the gambling industry, law, finance, information technology, economics, management, social work, or law enforcement. Clause 5 subsection 6, subclause 6, of the bill, excludes certain persons from appointment to the board of the commission, which are obvious. The list of ineligible persons would be persons who operated a gambling establishment prior to the bill coming into law, currently hold a license or will hold a license issued, intend to apply for a license, or have a financial interest in a gambling establishment. They would not be allowed to be members of the commission for obvious reasons. In order to further curtail and abate any question of influence, Clause 6.2 of the bill establishes a maximum period of 8 years in the aggregate for the appointment of any member of the board of the commission. So there's a term limit. After 8 years, persons will have to retire from the board. Clause 12 of the bill establishes under penalty that members of the board are mandated to submit an annual declaration that they have no actual or contingent pecuniary interest in any license or proposed license or licensee regulated or to be regulated by the Gaming Commission, or in any business or body corporate carrying on the business with which the Commission has the mandate to exercise its functions. The sum total of all of this is to ensure a functional and independent body charged with functions set out in Clause 13.1 of the bill, including regulation and control of the operation of gambling in Trinidad and Tobago, provision of information to regulatory, supervisory, and government agencies. For example, the Board of Inland Revenue, the FIU, the Integrity Commission, the Customs and Excise Division, the Commission of Police, Police Complaints Authority, and the Betting Levy Board. It will also address through the Rehabilitation Fund and the Development Fund the harmful and negative effects of gambling, and its other important function is to collect fees, taxes, and levies. In carrying out these functions, the Commission is empowered under Clause 13.2 of the bill, among others, to grant, renew, suspend, review, vary, amend, revoke, or cancel licenses, gambling licenses, that is, verify or cause to be verified the background, character, and reputation of an applicant and any associate, employee, relative, or other person, direct the implementation of a computerized internal enterprise network system or such other processes or procedures to facilitate interrogation, validation, and auditing of gaming and betting, and require verification of all income and other matters relevant to the business for which a license is granted. Clause 17 of the bill gives the Commission the power to hire its own staff and permits the secondment of officers from the public service or statutory authority. Clause 18 provides a wide source of funding for the Commission, including appropriations from Parliament, special grants, monies collected in respect of licenses, and so on, monies borrowed by the Commission, including securities. Clause 18 of the bill makes huge strides towards establishing the independence of the Commission from possible external influences in an industry where the stakes are very, very high and where the potential for criminal activity is also significant. Clause 24 of the bill provides that all surplus funds of the Commission are to be paid into the consolidated fund. This allows the movement of monies from under the Commission directly to the Treasury. Given that the Minister of Finance under clauses 21.4 of the bill is responsible for approving the expenditure budget of the Commission, there's a safeguard preventing the Commission from bolting the stable when it comes to financial acumen. So the Commission, just like the National Insurance Board, must submit a budget for the annual period for the approval of the minister. Clause 22 of the bill requires the Commission to keep proper accounts and records in accordance with best practice international standards. The accounts will be public accounts and subject to the purview of the Auditor General. Clause 23 of the bill requires the Commission to prepare an annual report to be laid in Parliament, similar to other authorities. Clause 28 subjects the Commission to the written laws governing the procurement of goods, works, or services in relation to the performance of its functions under the bill. The effect of all of this is that the Commission will be called to account, and Parliament will have the opportunity to ensure the Commission is within the boundaries of the law. Part 3 is the licensing regime. Clause 29 casts a very wide net in terms of activities now requiring a license from the Commission. Clause 30 establishes a minimum of 11 licenses as follows: a gaming operator's license to allow persons to operate a gaming establishment, a betting operator's license permitting persons to operate a betting shop, a gaming owner's license permitting a person to own a gaming establishment but not operate it, a bookmaker's license permitting the license to conduct betting activities other than pool betting, a promoter's license which permits the licensee to stage live racing and conduct pool betting, a gaming machine operating license which permits the licensee to sell or lease a gaming machine, a gaming machine distributor license, which permits a licensee to import and supply licensed gaming machines, a technical operator's license, which shall permit a licensee to install, maintain, and repair gaming machines, a premises license, permits licensees to conduct activities approved by the Commission at premises in a license, a personal licensee or license in respect of key employees within a licensed betting or gaming establishment, and a gaming machine manufacturer's license, which shall permit the licensee to manufacture, fabricate, assemble, and program gambling equipment. All of these licenses will convert the current amorphous, unregulated, unsupervised industry into a properly regulated one. I want to stress that all reports from the various financial authorities around the world have made the point Trinidad and Tobago is the only country in the world which has an unregulated gambling sector. These provisions not only protect the vulnerable, but also ensure that all gambling activity is conducted in a fair and transparent manner. And the revenue that is generated from the regime will redound to the benefit of all society, not just those who participate in gambling. Clause 31 of the bill further cements the role of the Financial Intelligence Unit as a supervisory authority responsible for anti-money laundering and so on. Clause 32, 33, and 34, and that's the proper entity to be responsible for AML, CFT, PF supervision of gambling establishments. Clause 32, 33, and 34 set in train the process and criteria for applying for licenses. The licensing regime is extremely robust. It is subject to provision of in-depth information by applicants, including AML, CFT, risk assessment, public scrutiny, as the notice of the application for a license must be published in at least 2 daily newspapers inviting the public to comment on the suitability of an applicant for a license. It allows the objection in writing from residents, teachers of a school, and representatives of any religious group in an area where a proposed gambling establishment is to be located. It also allows municipal and regional corporations, the THA, and other interested parties to make objections in writing if they so deem that to be appropriate. It includes a fit and proper test, an investigation of the applicant and its associates and its employees. Clause 34.3 of the bill permits the Commissioner of Police to cause such inquiries to be made as he deems necessary and provide a copy of his findings to the Commission. And therefore, this highlights the fact that we are not about anything that is vacuous or mere window dressing. This will be intense interrogation to determine whether people are fit and proper to operate casinos. Clause 38 of the bill sets the conditions for every license issued by the Commission. Some of the important conditions would be notification of change in director, beneficial owner, management and control, and so on. notification of a conviction of the licensee or associate or employee, consent to the entry of authorized enforcement officers to any premises, compliance with the Proceeds of Crime Act, the Anti-Terrorism Act, the Economic Sanctions Act, or orders made under those acts. Clause 39 of the bill requires all licenses granted, varied, amended, renewed, expired, etc., revoked to be published in the Gazette in at least 2 daily newspapers. So the public will be aware of all those persons operating legitimately and persons trying to operate illegitimately in the gambling industry. Clauses 42 and 43 of the bill treat with the expiration of licenses, the renewal of licenses, and so on. Clause 44 and 45 of the bill establish a review mechanism inclusive of suspension in the bill for licenses granted by the Commission. This is consistent with the rules of natural justice, whereby the Commission is required to notify and inform the licensee of the procedure to be observed during a review. Prior to the review, provide the licensee with an opportunity to make representation, answer any questions posed, notify the licensee of an action to be taken, and provide all of the defenses available under the rules of natural justice. At the completion of a review, the Commission may take a wide range of action against a licensee, ranging from a warning to suspension or revocation of a license. In the case of a suspension, subject to the rules of natural justice, where the Commission believes that an activity is being carried on in a manner inconsistent with the law or the framework of the legislation, a condition of a license has been breached, the licensee has failed to cooperate with a review, the licensee is unsuitable to carry on the activity, that would allow the Commission to take appropriate action. Clause 46 of the bill establishes the process for revocation of licenses. There are 14 grounds outlined, which range from the failure of the licensee to pay fees or levies, notification of the Commission by the Financial Intelligence Unit that the licensee has failed to comply with the Proceeds of Crime Act, the Anti-Terrorism Act, etc., as they relate to proliferation financing or any law relating to the prevention of money laundering, proliferation financing, and anti-financing of terrorism. Again, it is important to note that the provisions follow the rules of natural justice, and any decision of the Commission is amenable to appeal to the High Court. Clause 47 of the bill seeks to place an obligation on licensees to notify the Commission of any change in circumstances. Clause 50 of the bill provides for the appeal of any decision of the Commission to be commenced before the High Court within 30 days of receipt of the decision. Again, following standard dispute resolution procedures. Clause 51 of the bill establishes a register that is divided into public and private registers. The public register contains basic information, such as the name of a licensee, a list of every gaming machine or device granted under a license, and the address of every premises in respect of which a license is granted. The private register contains confidential information received by the Commission, inclusive of AML, CFT, PF, risk assessment, required to be submitted under Clause 32 of the bill. The Commission is duty-bound not to disclose information received during the licensing process that is not contained in the public register, unless so requested by the tax authorities, law enforcement agencies, or order of the court, or the private register. In a democratic society such as ours, this is reasonable as far as we are concerned. Clause 52 of the bill establishes the obligation of licensees to put in place systems of controls and accounting. Madam President, how much more time do I have?
At 1 minute to 11. So you have, it's 10:38 now.
So about 20 minutes, more or less?
Yeah.
Thank you. Clause 52 of the bill establishes the obligation of licensees to put in place systems of controls and accounting as required by the Commission. Some of the requirements would be human resource policies, practices, audit of financial statements by an auditor, procedures for the prevention of money laundering, terrorist financing, procedures for the discovery and prevention of fraudulent or corrupt practices, arrangements and procedures for the safety and security of the staff and the patrons at licensed premises, and procedures for determining and recording winnings and the payment of winnings. This must all be recorded. Part 4 of the bill deals with betting, and parts 4 and 5 deal primarily with gaming shops, betting shops, premises where gaming and betting activities are carried on. Clause 53 of the bill establishes a transitional period of 3 months from the date the bill comes into force to permit those operating under the Liquor Licenses Act or the Registration of Clubs Act to notify the Commission of their existence and provide proof of their existence and operations. During this transitional period, establishments operating under the Liquor License Act or the Registration of Clubs Act will be required to apply for the appropriate licenses. Pending the determination of the Commission on a pending application, the establishment will be permitted to continue operations. Let me repeat that. Pending the determination of the Commission on a pending application for a license, the establishment will be permitted to continue operations. I wish to emphasize that this applies solely to institutions that were in existence prior to the coming into force of the Act. This will apply to persons who own and operate betting shops, subject to the provisions of the Gambling and Betting Act under Clause 60 of the bill. Clause 54 of the bill mandates that a game of chance shall be played in person by participants, so not on the internet. Clause 56 of the bill endows the Commission with the authority to designate machines as either amusement machines or gaming machines. Clause 55 of the bill makes a distinction between gaming and simply participating in a competition or other arrangement where someone can win a prize, the latter of which is not to be regulated under this Act. Clause 59 of the bill exempts gaming that is carried on as entertainment. That is, games held for private gain where the amount of the proceeds appropriated for expenses does not exceed the reasonable cost of facilities provided for the entertainment. This will cover, among other things, bazaars and fairs and such other entertainments approved in writing by the Commissioner of Police. Part 6 of the bill, taxation and money. This part contains clauses 63 to 66 and deals primarily with the payment of taxes by entities carrying on gaming and betting. Clause 63 of the bill reflects taxes payable by a licensee holding a gaming owner's license on gambling tables and other devices in accordance with Schedule 5. The rate of these taxes as set out in Schedule 5 are as follows. For every baccarat table, $100,000 per annum. For every blackjack table, $120,000 per annum. For every Caribbean stud poker table, $150,000 per annum. For every dice table, $70,000 per annum per year. For every poker table, $60,000 per annum. For every roulette table, $120,000 per annum. For every electronic roulette device, $120,000 per annum. For every rum 32 table, $150,000 per annum. For every sip-sam table, $150,000 per annum. For every slot machine, $24,000 per annum. And for every other table or device not listed, $60,000 per annum. And these are gambling machines. And I want to make a clear distinction between these devices and amusement machines, which I want to repeat are not regulated under this legislation. The amusement machines in bars are regulated under the Liquor License Act. Madam President, there's an understandable perception that gambling results in a number of social problems, and it does. And Clause 64 of the bill establishes the Rehabilitation Fund and the Development Fund, both intended to ensure that in the economic output of gambling, funds will be directed in a purposeful and socially beneficial manner. The Rehabilitation Fund will financially assist non-governmental organizations and other groups with treating persons affected by gambling addiction and other psychological or physiological problems. The Development Fund will be used to generally assist in areas such as sport, health, social and community work, arts, and culture. To ensure that both of these funds can carry out their purposes, Clause 61.4 Mandates the Commission to deposit 2.5% and 5% of the monies collected from gambling and betting into the Rehabilitation Fund and Development Fund on or before the end of September in every year. So there's a fixed amount of money that must go into the Rehabilitation Fund and Development Fund every year. Clause 65 establishes committees for these funds independent of the Commission. These committees will comprise at least 5 persons who will be responsible for considering applications for funding and disbursing funds to organizations and groups engaged in the activities listed in clauses 64, 2, and 3 of the bill. The committees are also required to prepare an annual report on activities and management of the Rehabilitation Fund and Development Fund that will be laid in Parliament. Clause 66, 3, and 4 of the bill establish the accounts of the committee as public accounts. And this allows scrutiny by Parliament and accountability. Part 7, enforcement. Part 7 of the bill deals with the new enforcement procedures, and this is one of the areas where we have adjusted the legislation to prevent obstruction by persons opposed to the regulation of gambling. There are 2 main protagonists under this framework, the authorized officer and the enforcement officer. The enforcement officer, pursuant to clause 2 of the bill, is a constable or police officer appointed under the Supplemental Police Service Act. These officers are already clothed with the powers of the police. The authorized officer, on the other hand, is an officer of the Commission, designated under 67(1) of the bill. The difference between the 2 officers will be derived from the activities that they are required to deal with. The main activities to be performed by the authorized officer are set out in clause 67(2) of the bill. And these will be assessing compliance with the provisions of the Act, assessing whether activities are being carried out in accordance with the license, assessing whether an offense has been committed. So these are the activities of the authorized officer: gathering information, determining whether there's compliance or whether there appears to be an offense. The authorized officer is allowed under the legislation to monitor the activities of a gambling establishment, monitor and record the collection of funds, question persons on premises, whether by consent or at the offices at the Commission, at the premises or at the offices of the Commission, conduct detailed and complex regulatory, administrative, and background investigations, investigate complaints from customers and clients of licensees, and require assistance from other regulatory and supervisory government agencies, including FIU, FIB, Inland Revenue, Customs Excise, and so on. The last mentioned entitlement, which is requiring assistance from other supervisory agencies, demonstrates a level of synergy expected between the Commission and law enforcement. There will be close collaboration between the Commission and law enforcement, and this must assist in providing effective supervision and prevention of fraud, money laundering, loan sharking, other criminal activities, and unscrupulous matters which may occur within this sector, including the underreporting of revenue, which is a major problem at this point in time. I would think at this point in time, we're possibly collecting 10% or less of the revenue that we should be collecting as a country from the gambling sector. Clause 67(9) of the bill provides that an authorized officer may be accompanied by an enforcement officer, which is a police officer, in carrying out activities. Turning now to the enforcement officer, a police officer, it is important to highlight that pursuant to clause 68(1) of the bill, the areas of activity of the authorized officer and the enforcement officer are more or less the same, except for one thing. The enforcement officers, police officers, have an additional area of activity relative to assessing compliance with the proceeds of crime and other relevant legislations as they relate to proliferation financing and money laundering and so on, prevention of money laundering. The enforcement officer will be able to exercise police powers with respect to the control and treatment of those matters, money laundering, etc. I also want to point out that the FIU will be the supervisory authority responsible for AML, CFT supervision of gambling establishments, clause 31(1) of the bill. The application process mandates the submission of an AML, CFT, PF risk assessment, clause 32(3)(b) of the bill. There's provision of confidential information to the tax authorities and law enforcement agencies, clause 51(6) of the bill. And there's cooperation between law enforcement and the Commission in carrying out the activities of authorized officers. It is an express condition of each license to be granted to consent to the entry of authorized officers and enforcement officers in exercise of the powers under clauses 67 and 68 of the bill. But I'll turn now to a scenario where a gambling operator decides that they will not allow an authorized officer or an enforcement officer to enter the premises. Clause 69 of the bill, in those conditions, permits an enforcement officer to petition a magistrate for the provision of a warrant. So if in the event there's some casino that has something to hide and they are preventing authorized or enforcement officers from entering, that enforcement officer, police officer, can petition a magistrate to provide a warrant. That is another level of protection of the rights of our citizens. Clause 70 of the bill also mandates that an authorized officer who enters onto a licensed premises is required within 48 hours of entry to provide the Commission with a written report outlining the details of inspection. So again, that's another check and balance there to protect citizens, that if an authorized officer enters a casino, within 2 days, they must report to the Commission in writing, outlining their findings. Part 8, offenses and penalties, clauses 71 to 83. And these deal primarily with gambling and betting offenses, and divided into 3 divisions: gaming and betting offenses, offenses in relation to children, and general offenses. First division includes offenses such as using premises for gambling without a license, carrying out gambling activities without a license, cheating, betting in public places, etc. Clause 76 creates an offense relative to a person in Trinidad and Tobago inviting somebody outside of Trinidad and Tobago to participate in remote gambling. This is a matter that is very complex, and we have determined that we are not going to allow this at this time. If in the future the policy changes and sufficient controls can be put in to allow internet gambling, then we will revisit it. But at this time, we do not think we have the level of sophistication and capacity at this time to monitor internet gambling generated in Trinidad and Tobago. The fines are quite significant. They're all stated in the legislation. They range from 25,000 and 1 year imprisonment for some of the less serious offenses to 3 million and 7 years imprisonment for some of the most grievous offenses. Division 2, offenses in relation to children, are absolutely necessary to protect the young and impressionable in society, and touch on persons who may attempt to invite children to gamble, encourage children to enter casinos, employ children in casinos, and so on. Division 3, general offenses include for offenses not provided elsewhere in the bill. We also have allowed for administrative fines. This is something that is required by international bodies, so that there is the possibility of administrative fines through which the Commission may dispense any liability attached to the commission of an offense by the payment of a fine. The power of the Commission to enter into an administrative fine with anybody, however, is expressly subject to the consent of the Director of Public Prosecutions under clause 85(1) of the bill. You would not want a rogue commission to assist criminals by simply imposing administrative fines to avoid criminals from making a custodial sentence where it is warranted. So this is why the DPP has to come in and give permission to the Commission to impose administrative fines. In 85(6) of the bill, all monies recovered by way of fines are paid by the Commission and credited to the Consolidated Fund.
Minister, you have 5 more minutes.
Thank you very much. Part 10, just miscellaneous, address the Minister's power to make regulations under the bill, and relates to non-disclosure by the Commission and its officers of information obtained in the course of carrying out their duties standard clauses. Part 11 are consequential amendments. Clause 88 address the matter of consequential amendments set out in Schedule 7 to the bill. Schedules 1 to 6 address matters such as the staff of the Commission, fit and proper criteria, internal controls, counting systems, data requirements to be maintained for each machine, very important. There must be a record of the money deposited into a gambling device and the money paid out by a gambling device, taxes payable on gambling tables and other devices, fines, and consequential amendments. Madam President, we have been at this now, this administration, for almost 6 years. I have been in numerous Joint Select Committees. I have faced tremendous opposition from members of the opposition to this by some members of the opposition, and I have also witnessed tremendous support by some members of the opposition for this. We in the government believe this bill in another form with a special majority was already supported by all of the independent members of those Joint Select Committees and voted for by independent senators. That is when we required a special majority. Went to the other place and the opposition opposed it for spurious reasons. I'm very hopeful today that this bill will receive the support of this Honourable Senate. It cannot be that we have an unregulated gambling sector in Trinidad and Tobago with foreign interests, with persons from Eastern Europe and the Far East controlling significant influence in our gaming sector without regulation. It cannot be that that situation that has been there for 50 years be allowed to continue. I hope and pray that this bill receives the support of the Senate, and I beg to move.